will be participating in the decision and opinion in this case. I'll remind counsel that you each have 20 minutes to present oral argument, and there is a clock there to the left of the podium so that you can self-monitor your 20 minutes. And with that, counsel for the petitioner may proceed.
Hard to get on there.
I assumed that when I read the directions that the microphones are really large and it would be a very large item. I'm not so good at that. My name is Martin Sheehan. I am a bankruptcy trustee. In this particular case, I am also counsel for the bankruptcy trustee. And I know this court rarely hears issues that relate to bankruptcy issues. And I sometimes joke that I speak 2 foreign languages. I speak legalese and I speak bankruptcy. And while a lot of lawyers speak legalese, very few speak bankruptcy. So I'm going to probably start a little bit out of sequence because I want to. I think the presentation I made in writing about how the statute works are relatively clear. I would be shocked if the court did not have some concern about what was going to happen to the debtor if I was to prevail, and that's where I wanted to start my topic. And so, while bankruptcy is a set of rules, sometimes hard to follow, and reasonably applied by a judge, bankruptcy judges are like judges that yourselves and judges that you review. They are interested in seeing a fair outcome, something that does not end up causing harm to people on some technicality. It looks like I've raised the technicality, and I'll certainly assert that I have, but the likely result in this case, if the bankruptcy estate is to dispose of the value of a mobile home, or a manufactured home in this case, is to enter into some negotiations either with the debtor or perhaps with the secured lender that would not necessarily result in dispossessing the individual debtors, in this case, from their home. I have a similar case that I have resolved where Bank One had a lien on I think a double wide, and they had been paid off but had not released the lien, and a second bank had made a loan but had only recorded a deed of trust. Ultimately, the arrangement made in that particular case was that the second bank would advance funds to settle the case with me, would extend their security interest to the mobile home in accordance with motor vehicle law without additional charge to the debtor. And it's the kind of deals that get made down the road. Certainly, it's within the discretion of the court, and I will tell you to prove those kinds of things, and I'll tell you that they lean on trustees, people like me, to be fair. We had a similar problem years ago when we started to challenge motor vehicle liens. I argued a case called, we established some principles as a result of a U.S. Supreme Court case called Fink, and we ended up dealing with a lot of vehicles, and we did very much the same kinds of things at that time. So we are comfortable trying to make reasonable deals after a situation's been established. That is really a discussion about leverage, and I think all of you understand that in various legal contexts. It is about leverage and what turns out to be a fair deal and those kinds of things. I have an obligation to try and make sure that creditors, unsecured creditors, get paid. I take that obligation very seriously, and so I look under a lot of rocks to try and find that particular kind of cash. In this particular case, I am either a bona fide purchaser for value by statute, or I'm a bona fide lien creditor by the same statute. I'm a bona fide purchaser for value if we're talking about real estate. I'm a bona fide purchaser, I'm a bona fide lien creditor when we are talking about personal property. In this case, there is no doubt that the lenders did not secure a lien on the double-wide mobile home in accordance with West Virginia motor vehicle law. They have claimed that they did so as a result of some alternate scheme by claiming the property is affixed and that it's part of a deed of trust, and that that's the way they got to secure it.
And the deed of trust listed both the real estate and the double wide?
It did. I did not. I overlooked it originally, but that is absolutely correct. I don't believe it is the opportunity of the lender to make choices in contradiction to the statutory scheme. The scheme sets out that there is, in fact, an active motor vehicle title, and in order to promote lending on those kinds of vehicles, and in order to have a simple system, we have a lien system that's where you record liens with the Department of Motor Vehicles. If you want to discontinue that process, there's a statute where you file a document with the Motor Vehicle Commissioner, and he gives you a document to take and record at the courthouse. That wasn't done in this case. Not surprisingly, although not at issue in this case, there's a reverse process where if you've attached a vehicle to land, you can detach it and then put it back in the motor vehicle scheme again by complying with a slightly different but very similar statutory scheme.
It appears, though, in this case, the facts of this case, it would appear that the debtor and the holder of the lien intended to attach that double wide to the property, make it a fixture by their conduct, and in terms of listing the double wide as being part of the collateral named in the deed of trust. It was the property and the home, right?
I could certainly concur with your point of view about intent of the parties. Yes, sir.
So why wouldn't Snuffer versus Spangler apply? I know it's an old case, but why wouldn't it apply whenever you look at the three factors under Spangler or
Well,
Snuffer?
I think Spangler has been superseded by legislative action. Number one, we've passed motor vehicle title statute since Spangler was decided. We've also passed a couple versions of the Uniform Commercial Code since Spangler was decided. And we have gotten, modern practitioners are certainly used to the idea that you look for a lien on a motor vehicle with the Department of Motor Vehicles. You look for a lien on real estate in the real estate records. Historically, if you record in the wrong place, you're out of luck. So we don't really care to some extent about intent. I would concede the way the documents are written, you can make a good case for intent to be there. I'd be foolish to argue to the contrary. But this is not one of those situations where you get to take your pick. The truth is, if you get to take your pick, the cost of transaction goes up substantially because now you have to look in a variety of places to make sure that there is no prior lien if you're trying to make a loan. You have to look in the DMV records. You have to look in with the county commission. Arguably, you'd have to look with the Secretary of State to see those things too. And so these options all end up creating increased transaction costs for a lot of people that are not necessary. I mean, I know my rule seems to be a little simpler, seems to be a bit more black and white, but in a commercial transaction as this one is, that makes a great deal of sense. It would promote decision-making by the county assessors about taxation of these particular vehicles as well. So it is this is a small case. It is very technical, but it has wide-ranging implications across the law of the state of West Virginia.
So we have a memorandum decision that's a little more recent than Snuffer in November of 2018.
Yes.
And I think you're going to say that that's a family law case and not a commercial case, but why shouldn't we, as a matter of policy, just extend the holding of that memorandum decision?
Well, I was a little surprised when I read that memorandum because it came up pretty early in this particular case. And it says, it's pretty affirmatively a statement by this court that says, we don't care what the legislature did. That this is a choice that we're going to make based on a 100-year-old precedent, and we don't care how the legislature changed the law. I immediately responded and said, I don't think that that's the law in the state of West Virginia, because I don't think that's how we function. I think that there's a substantial need for deference by this court to the legislature when the law, in fact, has changed. Now, I'm not going to argue about the result in that particular case, because to me it's a squabble between family members, and I think that that's why it went off as an unpublished case. But I don't think it represents a significant and important reasoning for this court to adopt as it pertains to the relationship of this court to the legislature as a whole. I hope that answers your question, Justice Walker.
It does. Thank you.
If there are other questions, I'd be happy to answer them, but in the interest of time, and I'll cede the rest of my time back to the court. Thank you.
Thank you.
May it please the court, counsel. My name is Christopher Dawson. I represent the respondents in this case, Mortgage Electronic Registration Systems and WEI Mortgage Corporation. WEI Mortgage is the holder of the deed of trust, and Mortgage Electronic Registration, or MERS as it's referred to, is the nominee. The beneficiary is nominee under the deed of trust. In this case, we don't have any facts that we really need to go over. We've stipulated to it, and there's four main facts. There is a certificate of title for this mobile home. There's no
two of them, right? It's a
I believe so,
double-wide.
two halves.
Each half has a certificate, right?
Correct, Your Honor.
Okay.
So there's each half is titled with a certificate. There's no lien. My clients do not show any lien on those titles. For the purposes of this certified question, we've stipulated that the mobile homes, that both halves are affixed to the land pursuant to the Snuffer v. Spangler standard. So that's been stipulated. And it's also stipulated that the deed of trust was properly recorded on the real estate, and that deed of trust does in fact describe the mobile home specifically. So we've got the purely legal issue before the court. Is my client's lien perfected under what they've done with recording the deed of trust? There's no lower court decision to work with here because the bankruptcy court certified it to this court to issue a ruling, since it is an open question. My clients present that the question should be answered yes, that their lien is perfected and can be perfected under the stipulated facts in this case. There's really two sub-questions in the certified question. The first one is, can a mobile home be affixed to land for all legal purposes, become real estate without the title being canceled? Second question is, can a lender have a perfected interest in that without having in a mobile home that has been affixed without the lien ever appearing on the certificate of title? The petitioner relies on 17A-3-12B that provides the procedure for canceling a certificate of title. And that statute's detailed about the forms that need to be submitted. In turn, the certificates of title are canceled, and then there's a document recorded in the clerk's office putting that on record in the real estate records. That procedure exists, but there's nothing in that statute that supersedes the prior common law set forth in Snuffer v. Spangler. It simply lays out a procedure if you have a title and you want to cancel it. And nothing in there supersedes the law of this state going back to, I believe it was 1917 when the Snuffer decision was entered. It would have been simple for the legislature to include in that statute in order for a mobile home to be considered as part of real estate, the owner must cancel the title and follow the procedure. But that language isn't in there. It merely gives a procedure. And that fact that there was no requirement in that statute was recognized by the bankruptcy court in the Southern District of West Virginia in the In re Weichel case that I cite. And that issue was not a lien perfection issue. It came up between the debtor and the lender on whether the mobile home was a separate personal property or part of the real estate. So it's dealing with the same issue in a slightly different context. And the borrower, or the debtor in that case, was taking the position that they were separate and that it remained personal property because the title had never been canceled. And the bankruptcy judge specifically rejected the argument that 17A 312B provides the sole means to affix a mobile home. Footnote 3 in that opinion specifically addresses it, and the court says the legislature could have easily used language to make such a broad holding for that result for that statute, and they chose not to do it, or it's not in that statute. So that court went back to the Snuffer v. Spangler. The next case that deals with the affixing a mobile home without canceling the title is the Sanders v. Brown memorandum decision that Your Honor referenced. That was less than 2 years ago by this court. And true that the parties were family members. It was, I believe it was a mother and a son, but that didn't weigh in any way to this court's ruling in that case. It simply applied the long-standing common law to determine that that mobile home was affixed to the land because of intent and the remodeling and work that was done to affix it physically to the land. And in that case, the court allowed that mobile home that still had an active title, just like the one in this case, allowed that mobile home to be transferred by deed along with the real estate. So certainly these two decisions demonstrate that the statutory scheme in 17A-3-12B did not supersede or abrogate the common law. And the common law remains the law in West Virginia alongside of the statute. And clearly, if this court allowed a deed to transfer ownership of a mobile home, it follows that a borrower can transfer their equitable interest through a deed of trust in a mobile home that's affixed.
Counsel, before the statute was modified to allow this process of basically surrendering the title, it was somewhat unclear, wasn't it, in the law of when a mobile home or a manufactured home would become part of the property. And as I read it, it seems like the purpose of that statute was to clarify how that occurs, and instead of using indicia such as, whether the axles and the wheels have been removed or whether there's a foundation under different things that were used prior to that statute, but that statute was to be basically the definitive way of determining whether it's real property or personal property. And so if that was the legislative intent of that statute, wouldn't that sort of make it the sole way to determine that?
Well, that was, I believe, the purpose of that statute, to avoid litigation over whether it's a permanent foundation or decks or things like that. But I view it as a safe harbor provision. If you don't want to litigate all those issues and you want to ensure that that mobile home somebody's not going to come up and claim it's personal property, that this is a safe harbor procedure that you can go through and avoid litigation down the road and get rid of the title, so there's no question that's not personal property anymore. But there's nothing in the statute that says this is the sole means of doing that. So I believe the common law still remains, and it can cause problems because you might have to litigate whether it's truly affixed or not. But there's nothing in that statute that prohibits that argument or analysis.
Now, I agree with you, of course, that the statute does use may language. It's permissive as opposed to shall. But wouldn't it be If you accept the chief's argument that the legislature has established, has spoken, wouldn't it be in the interest of a creditor who normally is rather astute on all matters of state law when it comes to perfecting their interest, wouldn't it be just one box that the creditor needs to check, and you're asking us to not require your client to check that box, to go to the commissioner, ask them to cancel the title?
Well, it's a little complicated for the lender in some circumstances, dealing with the debtor whose name's on the title and the prior owner of the property and getting that transfer. I do a lot of real estate curative work before we proceed with foreclosures, and we'll have mobile homes that are 3 owners back. That's the name on the title in the DMV. And, you know, from the borrower's perspective, and this deed of trust doesn't have it, but many of them have affixation affidavits that they sign and say that it's affixed and permanent. So these people, lay people, are telling them, you know, that's my house, and it's there, and I'm not moving it. It's on a foundation. It's got a deck on it. So that's what I want to encumber with a mortgage to get a loan. So it's not as straightforward a process as it might appear. And it's certainly, many banks do go through with that and make sure that, excuse me, that the title's canceled. But again, I don't think that it's required under the statute because the language isn't there.
Does it matter what the deed itself says to the property? And in this case, can you point to anything in the deed to the real property that would support your argument that this should be considered as part of that overall real property purchase?
Well, I don't think the deed really, I don't believe the deed's ever been in the record in this case because we've stipulated that it is affixed. I think that would be a consideration as far as intent if the prior owner referenced a mobile home in a deed to the borrower that it's been affixed and we intend to convey it over. But in this case, we don't have to get into the elements in the Snuffer v. Spangler because we've stipulated that it's affixed.
Thank you.
The mobile home can clearly be affixed under common law, and as we've just discussed, the statute does not require the cancellation of the title. So once it's determined that the mobile home can be affixed without cancellation of the title, the next issue is, can the lien be perfected without it being on the certificate of title? And the short answer to that is yes, because once it's established a mobile home is a fixture and attached to the property, it's real estate, and a deed of trust encumbers real estate. So once that first analysis is done, the short answer is yes, the deed of trust is sufficient to perfect that lien. And as I said earlier, in Sanders versus Brown, that mobile home with the title was allowed to be transferred by deed. There's no reason that the mobile home can't be transferred by the interest in it by deed of trust to encumber the property. So the longer answer is to address the statute regarding lien perfection on a certificate of title, which is 17A-4A-3, which requires a lien on a certificate of title for a vehicle. And I think that's important that the legislature use that language, vehicle, because the mobile home is a vehicle when it's transported on going down the highway, on the tractor trailer being taken to the site, and if it's moved from a different site. But once it's on a foundation and it's been determined to be affixed as set forth following the Snuffer v. Spangler standards, it's no longer a vehicle. So I submit that 17A-4A-3 doesn't apply anymore once you get through the first analysis of whether it's affixed or not. And again, there's no mandatory language in this statute. And in my brief, I also practice in Kentucky, so I'm very familiar with the effects of not having a lien on a title in that state. And I cited a case in that statute, and in Kentucky, the similar statute says any property that has a certificate of title, you can only get a lien perfected if it shows on that title. It's clear cut. If we were In Kentucky, my clients would have no case. There's no such language in West Virginia. It talks about a lien having to be on title for a vehicle. And once we get through the first analysis, it's no longer a vehicle, so the lien doesn't have to be on the title. Petitioner doesn't cite any cases that support his position. The one case was a Virginia law case. It's not applicable to here, but I wanted to get into Dotson versus One Valley Bank cited by petitioner. That's another bankruptcy case from before 2004 when the cancellation statute went into effect. But the important thing to note in that case is the lender filed a UCC financing statement trying to encumber a mobile home. The mobile home in that case was on leased property. It wasn't on the same property owned by the borrower. But significantly, the reason I want to point out that case is the bankruptcy court even then noted that if there had been an argument that the mobile home was affixed, that would trigger a different set of perfection rules. So even in that case where the court found the lien wasn't perfected because of UCC filing, it referenced that a fixture changes the analysis. And that's what we have here. We have a mobile home that's affixed. It's stipulated that it's affixed. And once it's affixed, it can be transferred by deed. It can be encumbered by a deed of trust. And there's no further analysis of the statutes necessary. Thank you.
Thank you.
Please take your microphone cover before you sit down. Thank you.
I wanted to respond briefly. There is a stipulation in this case, and it appears at page 224 of the appendix. And it provides, for purposes of certification of legal question, the pending motion for summary judgment, MERS and WEI contend the manufactured home is physically affixed to the real estate for all intents and purposes. The trustee does not contest that contention at this time. It was necessary, in my judgment, to make that concession, to make the litigation function. So I have not conceded for all time that the property is affixed. They've alleged that. I'm happy to deal with that in that case. If you want to assume that fact, that's fine. The other thing that Mr. Dawson said was, if you do it the other way, there can be litigation. I thought we were trying to save money. I thought we were trying to avoid unnecessary litigation. I think that's the primary purpose of the statute. We're trying to end litigation. I'm in litigation because people didn't follow the rules. The suggestion that we have all this litigation about how manufactured homes are attached is not a productive exercise for anyone in our society. I did, Justice Armstead, look at what is a mobile home. At one time, as a trustee, I contended that the axles and the tongue on a manufactured home were the thing that made the box a vehicle. Turned out I was wrong because we wanted the lending documents that related to the box to work, whether you took the tongue off and whether you took the wheels off and the axles off. It's surprising to me that when you buy a double wide, you don't buy the axles, you just buy the box. They don't even sell you the tongue. They take it back and they reuse it. And so the argument that we should engage in a long-standing and case-by-case analysis, it might sound wonderful as an outcome for decision-making, but in fact, it is contraindicated by larger principles of law to make things simple and settled. I talked about this a little earlier. This is the need to allow property to be looked at. What is it? Where do I look to see if there's a lien? I've looked there, it's there, or it's not there. I'm done. Engaging in a endless circus to look in a variety of different places is not a productive thing at the law. Those are my comments, and if there are further questions,
I just have
I'd be
one
happy to
question. It's more a matter of curiosity, since you, as you noted at the outset, are experienced in bankruptcy court, given that Snuffer was decided as long ago as it was, and that this statute has been around for a while, it surprises me that this issue hasn't come up before. And so I wonder, is there something unique about this case, or is just this the one that happened to get teed up to, so to speak, to make it to our court?
Judge, it's a keyed-up issue, and quite honestly, one of the things that has changed, not in the law, but as a practical matter, we changed the forms in bankruptcy proceedings relatively recently, in the last few years. One of the things that the forms now require is when you claim certain kinds of real estate, you have to identify what it is. Are you claiming it's a single home? Are you claiming it's commercial real estate? There's a variety of things. If you'll indulge me for a moment, I'll look, and I'll tell you what page of the appendix I'm on. Yes, Judge, if you look at what is appendix page 22, it will be a bankruptcy form called AB, and A is for real estate and B is for personal property. And A now requires a single-family home, duplex or multi-unit building, condominium or cooperative, manufactured mobile home, land, investment property, timeshare, other. And quite honestly, as a result of that indicator, it's become easier for a trustee to identify whether property is or is not a double-wide mobile home. In this particular case, the answer was, they didn't check this answer, they treated it as part of the land. Nonetheless, I did see it, and I've become a little bit more alert to that. So I think it's an alert issue. It's not so much a fundamental change in the law. So I reached for it, and that's how I looked at it. And quite honestly, I went to a seminar and learned some things about out-of-state practices, and quite honestly, those are the things that have influenced me over time.
All right, thank you.
Anything else? Thank you, Your Honors.
Thank you. This case will be submitted.
The next case for oral argument is also under Rule 20, Cynthia McCoy and others versus Stephen Dragicich, docket number 190018, an appeal from the Circuit Court of Hancock County, West Virginia. I'll remind counsel that you each have 20 minutes per side to present the oral argument, and I'll let you know that although Justice Workman is not here in the courtroom this morning, now briefly after this afternoon, she is viewing the webcast and listening, and so she will be participating in the decision and opinion in this case. With that, you may proceed, and there is a clock to the left of the podium to monitor your time.
This case comes before the court from the Circuit Court granting summary judgment for Attorney Dragicich. My name is Frank Duff, and I represent the petitioners in this case, who are the children of Hilda Bain.
Counsel, I would interrupt, but you may leave your mask on or you may remove it if you wish to. It's certainly up to you.
Is this better, Your Honor?
It's up to you. If you'd rather leave it on, that's fine. I just wanted to make sure you were aware that if you wish to take it off while you're addressing the court, you may do so. You certainly don't have to do so. If you prefer to leave it on, that's fine as well.
Thank you, Your Honor. Hilda Bain died on January 19, 2010 because of medical negligence that occurred at Wheeling Hospital and Acuity Specialty Hospital. After her death, her children retained a lawyer by the name of Marcy Griskovich on March 26, 2010. And she retained Marcy Griskovich to represent her in a wrongful death action and also to remove her stepfather, Richard Bain, who was the executor of Hilda Bain's estate. And the reason that the children were concerned about the stepfather's involvement was his son, his natural-born son, was a respiratory therapist at Acuity Specialty Hospital where some of the malpractice occurred. And in fact, he actually treated Hilda Bain. So they wanted him removed as the executor because they were concerned that he would not adequately pursue a wrongful death case. So on June of 2010, Richard Bain, who was the executor at that time, closed the Hilda Bain estate. It was done and it was closed in June of 2010. In August of 2010, Attorney Dragisich was hired by the law firm of Griskovich and Curtis. Now, it's important to note that even though Mr. Dragisich was hired as an associate of that firm, he had 9 years of experience. And that experience included working for the Attorney General's office, working doing defense litigation for the Spillman firm, and serving as a municipal court judge. So he had significant experience. After Mr. Dragisich was hired as an associate at that firm, Ms. McCoy, one of the plaintiffs, received a call from Ms. Griskovich's office saying, you need to come in because we want to revise the contingency fee contract, or the retainer agreement, to include Mr. Dragisich and to increase the contingency fee from 30% to 40%. So as instructed, Ms. McCoy went into the office. She met with Attorney Griskovich, she met with Attorney Dragisich, and she signed the agreement. At that time, Mr. Dragisich, per his own testimony, told Ms. McCoy that he would be working on her case. He also testified that he looked over the retainer agreement before he signed it. Now, the retainer agreement is an important aspect of this case. And if you look at the retainer agreement, in the very first paragraph, it indicates that the agreement is between Marcy Griskovich and Stephen Dragisich and my client, Cynthia McCoy. It goes on to say that the agreement is to provide legal services regarding an incident regarding the estate of Hilda J. Bain. The only incident was the death of Hilda Bain and the removal of Mr. Bain as an executor so that the wrongful death action could be pursued. Because remember, at that time, the estate had been closed. The next paragraph says that 40%, a 40% fee would be collected upon settlement. And then finally it says, attorneys agree to perform to the best of his or her abilities and to exhibit due diligence in the conduct of said services. Mr. Dragisich signs the first line of the agreement. There is no separate signature line for the firm. He signs the first line, and the other attorney, Marcy Griskovich, signs the second line. Now, the briefing here shows that Mr. Dragisich is claiming that he thought that he was only doing estate work. Well, I don't know of any estate work that's done on a 40% contingency fee. And there wasn't any estate work to be done because the estate was closed. So even though the estate was closed 6 months earlier, the argument here is that the retainer agreement shouldn't apply because Mr. Dragisich thought that he was only being used or entering into the agreement to do estate work. It's clearly not the case.
Counsel, what is in the record that you can point to that, if anything, that shows that Mr. Dragisich actually had any communication with the client, did any work, specific work on the case?
Other than the initial meeting, Your Honor,
yes,
there was no communication because this case is a case about omission. And what we're really dealing with is omission. And so what occurred here was there was a significant omission by Mr. Dragisich because once he signed that agreement and once my client signed the agreement, and we have this wrongful death action pending out there, and we have the necessity to remove Mr. Bain as the executor, Mr. Dragisich did absolutely nothing. He never interviewed the clients. He never looked at the file. He never had any conversations with Ms. Griskovich to determine her knowledge about the case. He never accumulated the medical records. He never retained an expert. He did absolutely nothing. And in fact, when he left the firm, he didn't even tell my clients that he was leaving. My clients did not have a choice in regards to the attorney that was going to continue to do their work.
Counsel, I want to make sure, just again, we're focused on the when was an attorney-client relationship established and when did it end, if it ended. And you referenced in your comments that Dragisich joined the firm, I think, in August of 2010. And of course, we know that on January 3rd of 2011, the new retention letter. Is it your position that the attorney-client relationship with Dragisich began in January or when he joined the firm in August?
I believe it occurred in January when he signed that retainer agreement.
And then he left the firm in April, 4 months later.
That is correct,
3
Your
or
Honor.
4 months later. And in your response to the Chief's question, other than the execution of that retention letter in January, either before that or after that time on January 3rd, no other communication, no representation in terms of engagement in an attorney-client relationship by this individual?
He did nothing.
Okay.
And so when you look at the legal analysis here, the circuit court found that there was never a formation of the attorney-client relationship for 2 reasons. The first reason is that the plaintiffs never knew Mr. Dragisich and never expressed any desire to employ him. And the second reason was Mr. Dragisich signed the retainer agreement in his capacity as an associate. They're the 2 reasons that were provided by the circuit court as to why no attorney-client privilege or attorney-client relationship was entered into. Now, if you look at the first issue, whether or not the plaintiffs expressed the desire to employ Mr. Dragisich, clearly, if anything, at the very least, that's a question of fact. My client went to the office. She had a meeting with him. She reviewed the retainer agreement. She signed the retainer agreement and, in fact, agreed to increase the contingency fee based on Mr. Dragisich's representation that he would be working on the case.
Would you mind focusing, if this court believed that by the actions following April, the letters that your client received following the dissolution of the law firm in August, focus on the way in which an attorney-client relationship ended and why your client would not have understood, based on the correspondence, the letter they received, that after the breakup of the firm, the representation from the other attorneys saying that they would continue to handle and represent the clients.
Yes. Your Honor,
did not end that relationship.
Your Honor, it's my understanding that the client should be given that choice. And so when Mr. Dragisich left, since he had signed the retainer agreement, someone should have notified, I would think Mr. Dragisich, my client, and then my client had the ability at that point in time to make a decision as to who handled the case. That was never done here. And in fact, all of this in terms of Marcy Griskovich coming in later on and saying that she was going to keep the case, that was after the statute of limitations had already expired. So the statute expired and my clients were unable to pursue a medical negligence case involving the death of their mother.
When Mr. Dragisich left the firm, had the statute run at that time?
No, it did not, Your Honor.
About 4 months later, I think?
I believe it was 3 or 4 months after he left.
I have the statute limitations ran on January 19th of 2012, and your client was sent a letter back in August of 2011 about the fact that the firm had been dissolved and that she would be representing her moving forward.
Your Honor, it's our position that when Mr. Dragisich left, because he had signed the retainer agreement, she should have been notified. At that point, he had already left. She had no choice. And so that is our position in regards to this. And so,
And when your client received a letter on January 10th asking if you still had an interest in pursuing the Med-Mal claim, that was 9 days before the statute expired. And did your client respond to that letter?
I don't believe that she did, Your Honor. I don't recall that occurring, no. So, basically you have the two issues here, and I think that the court needs to be guided by the Keenan versus Scott case. And I think the language in Keenan versus Scott, which is a case that's been law in the state of West Virginia for 110 years, is pretty clear. And that case says that as soon as a client has expressed the desire to employ an attorney, which occurred here, and there has been a corresponding consent on the part of the attorney to act for him in a professional capacity, which occurred here, the relation of the attorney and client, the relationship between the attorney and client has been established. And so that part of the Keenan case is extremely clear, and that's been the law in the state of West Virginia now for about 110 years. The second issue, and something that's been brought up here, is that the fact that Mr. Dragisich did nothing. This is a case about omission. And so if you look at Rule 5.8, the Rules of Professional Conduct, which would apply, that specifically provides that nothing in that rule or the laws under which a lawyer or a law firm is organized shall release or relieve the lawyer from personal liability for acts, errors, and omissions. So what's occurred here is an omission. And then if you go to the code and you look at 31B 13-1305D, that specifically provides that employees, including associates, can be held liable for omissions. So,
Well, then the issue that arises would be at what point did the attorney-client relationship, if one existed, at what point did it end?
well, and that's a very good point, Your Honor, because given the fact my clients never had notice until August, I believe, then arguably the latest point in time would have been sometime several months after Mr. Dragisich left.
So if they got a letter in August and were informed that Griskovich, is that how you say that?
There's two lawyers here, Griskovich and Dragisich.
All right, Ms. Griskovich was going to keep the case. That happened in August, and it didn't run, the statute did not run until January.
That's correct, Your Honor.
Okay, so that's roughly 4.5 months.
Yes.
Correct? Did the attorney-client relationship between Dragisich and your client terminate at that point, that when she was notified that the firm was gone, that she was going to keep the case?
Well, Your Honor, given the fact my client was never given the choice, which he should have been given, there's an argument that it did not, that relationship continued on even though the statute of limitations then expired, because my client was never given the choice. And so that's I think a significant issue in this case.
Thanks.
Wouldn't they have been given the choice, though, if they really objected to Ms. Griskovich continuing the case, they would have had that opportunity at that point to raise that, would they not?
They would have, Your Honor, but he had already been gone for a number of months at that point in time. So the way that it should have been done was that when he left, there should have been a letter written to my client or some notification to my client that he was leaving. This is standard practice, that he was leaving, and that the client then would choose which lawyer would be representing her and her family in this.
Would the lawyer have an opportunity to say, whoa, wait a minute, I'm leaving the firm, I can't take that case. I don't have the capacity to handle that case, and therefore terminate the relationship himself?
Your Honor, I think that he would have that capacity, but that did not occur here. I mean, he never told my client that he was leaving, and he never told my client that that he wouldn't have the capacity to handle the case. So,
She got a letter, or your client got a letter, but identifying who the relationship, the attorney-client relationship was going to be governed by, but you just think it came from the wrong person
Well, I think the
exclude-
timing is wrong, Your Honor, and I think it came from the wrong person, because in my mind, the way that it should have been done is when Mr. Dragisich left, any cases that he was handling, letters should have went out to those clients, so the clients would then have an opportunity to choose their lawyer. And that did not occur here. And so, I think that is a significant problem here. But I think that in regards to the damage that occurred to my client because of the omissions here, that's clearly a question of fact. That's not a question of law. And so I know we're all talking about when the statute of limitations occurred and the fact that Mr. Dragisich had left before the statute of limitations had occurred. He did nothing. And so the fact that he did nothing and didn't provide any representation at all to my clients, that's a question of fact as to whether or not that damaged my clients. It's not a question of law. And so it's our position that that my client has a right to pursue this malpractice case against Mr. Dragisich, that the jury should determine the extent of his omissions and whether those omissions, as a matter of fact, caused my client harm. So that's our position. Thank you very much.
Thank you.
Please remove your microphone cover before you sit down. Thank you.
Ansel Ramey and Ben McFarland on behalf of Steve Dragisich, Bob Fitzsimmons, and Bill Wilmoth on brief. This case has profound implications for the practice of law, particularly for young lawyers. You're a young lawyer, you go to a law firm, you're there 3 months. Partner comes and says, listen, I want to introduce you to a client, I want you to sign off on a retainer agreement. Doesn't even explain to you what the matter involves. You go in, you meet briefly with the client, you sign the retainer agreement. You never hear about the case again, never work on the case. You leave 3 months later. There is an agreement, it's in writing, which cases are being retained by the firm, which you're taking. The letter is very explicit, page 237 of the appendix, that all other cases and clients not specifically mentioned above shall be the sole property and responsibility of Grisovich and Curtis. In writing. Statute hasn't run, you've never worked on the case, never been asked to work on the case. And by the way, we're here on a motion for summary judgment. We submitted sworn testimony of Mr. Dragisich saying, other than my capacity as an employee of a law firm, I was never retained as an attorney. Well, what did Ms. McCoy have to say about that? Page 316 of the appendix. Question. You know, you've testified several times that Marcy said she had other attorneys, including Steve Dragisich, that have come on board, correct? Answer. Well, she didn't name them. She just said she had other attorneys on board. Question. Do you agree, to your knowledge, Dragisich never represented to you or anyone else that he was handling the malpractice claim? I cannot answer for my sisters and them because I don't know what exactly that they had talked to him about. I can only tell you I've never met the man and I've not talked to him. That's a sworn testimony in front of Judge Wilson. Now they want to get up here on appeal and argue, oh, well, you know, maybe there was confusion. You look at the retainer agreement. Mr. Dragisich signed it. Ms. McCoy signed it. There's a sworn testimony in the record. I never met the man. I was just told by an owner of the firm that she had other lawyers working on the case. Now, fortunately, you know, this is the first time this court's had to deal with the issue presented here, but other courts have dealt, and we cite those in our record. In a case, Myers versus Maxey from Oklahoma. The plaintiff sued two attorneys, Eva Maxey and John Preston. Although Preston signed the engagement letter, just like this case, and discussed certain aspects of Escal's last will and testament with Maxey, it was Maxey who drafted the will and ultimately exercised control over that part of the legal work. The Oklahoma Court of Appeals said, Preston was not a principal in the firm. He was not a shareholder, director, or officer. And he did not possess or exert any direction or control over preparation of the will. Therefore, we affirm judgment in favor of Preston, just like this case. In another case, Estate of Mitchell versus Doherty, this is out of Michigan. The clients brought a legal malpractice action, missed statute of limitations, just like in this case. And in this case, one of the attorneys employed by the firm retained left, and upon the attorney's departure, the case was retained by the original firm, just like here. Also, as in this case, the departing attorney did not provide any professional services for the plaintiff following his departure from the firm. Again, the court held, a client's employment of one member of a law firm is generally deemed to be employment of the firm itself. Defendant law firm does not dispute that an attorney-client relationship existed between it and plaintiffs, but the court goes on to hold, but signing an engagement letter on behalf of a law firm in which you have no ownership interest is not hiring you individually. And then the final case is Devereaux versus Love, which is an Indiana case. The clients brought a legal malpractice action against an attorney, and what happened there was the other attorney was subsequently sentenced for defrauding clients, and the court said the designated evidence reveals that by the time Devereaux, the departing attorney, learned that Conroy had mishandled the cases, Devereaux was not serving as a Lowe's attorney. And we're talking about, they want to talk about sins of omission. He was there 3 months after he signed the retainer agreement. It's undisputed. No one ever asked him to do anything on the case. Undisputed. He never met with the clients. Undisputed. All of this is undisputed. So, you know,
was there created an attorney-client relationship when he signed that retainer agreement?
There was an attorney-client relationship between the McCoy clients and the law firm. And had he committed malpractice during his employment with that law firm, he could be sued under the professional limited liability statute in an individual capacity. But he didn't, he committed no act. He didn't do anything. And the statute has been noted. The statute of limitations expired long after that. And this is also significant. I think it's been mentioned, but I wanted to point to the place in the record where it's mentioned. A letter goes out. Okay, understand that before Dragisich is ever hired by the firm, there was already a retainer agreement before he was ever hired between the McCoys and the law firm. So then he joins the firm. There's a second retainer agreement executed on which he signs. But then a letter goes out. August 30th, 2011, it's on page 239 of the record. Dear Ms. McCoy, please be advised that my private practice physical location has closed. I've taken a position full-time in the Hancock County Prosecutor's Office. However, my paralegal, Melissa Miller, and I are still handling the matter we were retained on. So, I mean, these people can't be confused. I mean, even the law firm doesn't exist anymore. I mean, you have a law firm retained. When my client was an associate, he leaves in 3 months. That law firm becomes no longer in existence. And it's also referenced in the record later. It's on page 241 of the record. In January 10th, 2012, she left the prosecutor's office and formed Griskovich Law Office. Dear Mr. Bain, this is to Mr. Bain. As a follow-up on my private conversation, I kindly ask you to please contact me and advise us that the statute of limitations is going to expire. But the significance of that, closed caption, carbon copy at the bottom, Diane Swango on behalf of the heirs of the estate of Hilda Bain. They were kept informed of the whole thing during the complete process. Nobody was looking to my client for anything. That's the sworn testimony. That's the evidence in the case. And you're imposing, as Judge Wilson, I think, wisely noted, lawyers come and go in law firms. You know, at times we have 300 lawyers. We've got over, 100, 125, 140 associates. They come and go. You don't have to inform every client of an associate's departure when they leave, so the client can make a choice. It's not, as been noted, it's not the associate's choice. He doesn't have any ownership interest.
But again, going back to Keenan in 1908, in the syllabus point 1, it says, as soon as the client has expressed his desire to employ an attorney and there has been a corresponding consent on the part of the attorney to act for him in a professional capacity. Isn't that exactly what happened in the second retainer agreement? And you've got Dragišić right there signing that retainer agreement. And now, and wouldn't the estate view that attorney as having a relationship with the attorney rather than just the firm?
No, based on what I've referenced. First, Ms. McCoy's own testimony that she was not retaining Mr. I mean, the only way to read that testimony. She said, I was told by Ms. Griskovich that she had other lawyers working. And she was asked specifically, well, did you understand that Steve Dragišić was your attorney? She said, I never met the man. And that's what's in the record. And Steve Dragišić's testimony, there's two parts to that. The second part is, quote, there be a corresponding consent on the part of the attorney to act for him in a professional manner. Steve Dragišić testified, and the record's undisputed. Ms. Griskovich didn't testify to the contrary. Ms. McCoy didn't testify to the contrary. There's no evidence in the record to the contrary for Steve Dragišić to contradict his testimony that I thought it was an estate matter, because that's what the retainer says. I mean, it says, the second retainer agreement at the top of it says, first of all, it says State of West Virginia, County of Hancock, Griskovich and Curtis Law Office, PLLC. And it says, the client hereby retains and employs attorney to legal services concerning an incident regarding the estate of Hilda V. Bain. And his testimony is, I was never told about, sworn testimony, I was never told about any wrongful death proceeding.
No, but at the time he signed it, the estate was closed.
He didn't know that. Nobody told him.
Well, he's a lawyer, he should have. I mean,
Well, he's an associate. I mean, he's called in, the partner
An
comes.
associate is not a lawyer?
Well, he's a lawyer, but he's not asked to do anything. All he was ever asked to do was sign the retainer agreement. He wasn't told what the estate matter was, what it consisted of. He wasn't told anything about it.
Counsel, if we took the petitioner's position on this, which made some very good arguments about the fact that he did meet with the clients. Well, would that require, I mean, I'm trying to play that through, would that require every time an associate or even a partner leaves a firm that they write every client of that firm and say, I'm leaving the firm and, in case you believe I was your attorney, I'm not going to be any longer?
Completely unworkable. Petitioners argue that. They argue that when Dragišić left, somebody should have notified them and given them an opportunity to do that. You'll notice what legal authority they cite for that proposition. The answer is none. I mean, here's the other thing. Just to be practical, boots on the ground, what happens. If I'm a small practitioner, like the one in this case, I'm having every associate sign off on every retainer agreement. You know why? Because associates come, associates go. Mr. Dragišić was there 8 months, and guess what I get? Free malpractice coverage, because those are claims-made policies. So when the associate leaves and goes to Steptoe and Johnson, or goes out on his own like Mr. Dragišić did, or goes wherever, and there's a legal malpractice policy, guess what? That policy covers when it was never underwritten to cover that sort of thing. And if I'm the scheming small-town practitioner, I never purchase legal malpractice coverage myself, because you know what? Every associate goes through here, I make them sign every retainer agreement. And it's just, the implications of this case are pretty profound. Now, how often do lawyers have associates sign retainer agreements? I have no idea. But to the extent they do, that's a practical problem.
But isn't the problem here that we're here on summary judgment. I mean, you've recited testimony and back and forth and all of that, why wouldn't a jury be entitled to determine these issues? And you make these great arguments about how, an associate isn't a lawyer or whatever it is. Why should we go along with truncating this matter and resolving it on summary judgment?
Because once we filed a properly supported summary judgment motion with sworn testimony, Ms. McCoy's sworn testimony, Mr. Dragicich's sworn testimony, under Powder Ridge, the burden shifted to them to respond with evidence. And I read you the evidence. The part that I read was what they attached to their response. And then it's unfair to Judge Wilson, right? I mean, he has to rely on the evidentiary record before him when the summary judgment is tendered. Your review's de novo, but you have to find in the record where there is a genuine issue of material fact. And when there are two components, one, the client thought they were hiring a particular attorney for a particular matter, and the client here testifies, I never met the man. I just knew there were other lawyers involved. That's a sworn testimony. And when the second part is the lawyer has to understand that he or she is being hired by this client in a particular matter. Mr. Dragicich's testimony, which is undisputed in the record, no one ever told me about wrongful death matter. I was never asked to work on the case. That's what Judge Wilson had to work with. So when that's what he had to work with, it's our submission he correctly granted summary judgment. They should have come back with they couldn't come back with an affidavit because we had her deposition, but they should have asked her in her deposition, Ms. McCoy, isn't it true that you understood that Mr. Dragicich was your attorney in a wrongful death matter? And if she said yes, I would agree 1,000% with you. That didn't happen. We have what I read. Thank you very much. Yeah.
Justice Walker brought up a very good point, and he said, isn't this a question of fact? And one of the cases that was relied heavily upon by Attorney Dragicich's attorneys was the DeFrancis case. And that's a West Virginia case. It's a 1994 case. And if you go to, I believe it's the 4th page of that case, the court specifically states, whether a client-lawyer relationship exists for any specific purpose can depend on the circumstances and may be a question of fact. So at the very least, even if somehow this court could decide that the retainer agreement doesn't count, just decide that, at the very least there's a question of fact here. Now, counsel argued that Ms. McCoy didn't recall a meeting with Mr. Dragicich. Well, Mr. Dragicich's own testimony was that he and Ms. Griskovich met with Ms. McCoy, and Ms. McCoy was specifically told that he would be working on the case. And that's why she agreed to an increase in the contingency fee from 30% to 40%, because there were now 2 lawyers working on this case. The other interesting thing is, and I think it came up in some of the questioning here.
Before you move on from that, was she informed specifically that he would be or that another lawyer would be?
Dragicich testified that he would be working. In other words, in that meeting it was said that Dragicich would be working on her case. And he was in that meeting.
Is that in his testimony in the record?
I believe it's in his testimony, Your Honor. Also, I think another question that was asked here is insightful. The retainer agreement doesn't tell the client that Mr. Dragicich is an associate, doesn't tell the client that as an associate he's not going to bear any responsibility or liability, and that he can simply choose to do nothing in regards to the case. The retainer agreement doesn't say that. In fact, the retainer agreement says exactly the opposite. The retainer agreement says that the attorney, and in this case, Ms. Griskovich and Mr. Dragosich, agree to perform to the best of his or her abilities and to exhibit due diligence in the conduct of said services. And that did not occur here. So if you look at this retainer agreement simply as a contractual document, which in essence it is, that was not done. There wasn't any due diligence by Mr. Dragosich in this case. The other interesting point I think that can be made here is that if the court says that if a associate signs, and this is a 9-year lawyer, this is a lawyer with 9 years of experience, that if an associate signs a retainer agreement and does nothing, that there's no liability on behalf of the associate, I guarantee a lot of partners are going to become associates because there wouldn't be any responsibility in regards to the lawyer signing that retainer agreement. So in order to preserve the practice in the state of West Virginia and the responsibility of lawyers to their clients, if you sign a retainer agreement and you read it and you know what it says and you say you're going to use due diligence and you don't, there should be some responsibility there. And certainly there's an attorney-client relationship that was formed. And if anything, there are questions of fact in regards to this case. Thank you.
Thank you. This case will be submitted.